There's a document sitting in a founder's inbox in Bengaluru right now. It's a 5 crore rupee deal, the biggest of his life, and it contains a single sentence that will bankrupt his company in 6 months. He doesn't know it yet. He thinks he's safe. His lawyer gave him a checklist, but that checklist is the very thing that will bring his walls crashing down. Let's be blunt. The contract review checklist your lawyer gave you is a liability. It's a tool for amateurs. It's the reason why countless Indian startups, after celebrating their biggest deals, quietly face catastrophic losses, because that checklist asks the wrong questions. It asks if you have a wall, not if that wall is made of paper. The Bengaluru SaaS startup I mentioned, their story is a cautionary tale for every entrepreneur in India. They landed a landmark deal with a major enterprise client, 5 crore rupees. The champagne was popped. The team celebrated. Their lawyer had ticked every box. Indemnity clause, check. Confidentiality, check. Governing law, check. The checklist asks, do we have an indemnity clause? It's a yes or no question. It's the equivalent of a fortress guard asking, do we have a gate? Without asking if that gate is locked or if it's connected to a wall. 6 months after signing, a minor data breach occurred. It wasn't their fault. It originated from a third-party API they used. But the client sued them. Why? Because a single misconfigured phrase in their indemnity clause failed to protect them. The checklist provided a false sense of security. It focused on the presence of clauses, not the interplay between them. This is the fundamental flaw in how 99% of founders approach contracts. They treat it as a final, annoying administrative task, a collection of parts. But elite operators, the founders who build enduring companies, they understand a profound truth. The contract is not the end of the negotiation. The contract is the strategy. It's not a document. It's a dynamic system for allocating risk and creating leverage. So you have a business. You're generating revenue. You're signing clients. And with every signature, you are walking this tightrope. You just don't know it. You believe your standard contract protects you, but that template you downloaded, it's a ghost. It has no context of your business, your risk appetite, or the 50 lakh rupee threat hiding in plain sight. Think about the deals you've already signed, the vendor agreement for your core software, the client contract that makes up 40% of your revenue, the partnership deal that gives you market access. Right now, buried in one of them could be a ticking time bomb, a weak force majeure clause that won't protect you from the next supply chain shock, a limitation of liability clause riddled with exceptions for gross negligence, a term so vague it practically invites a lawsuit. The Bengaluru startup didn't fail because of one bad clause. They failed because they had no system. Their weak limitation of liability, the core vault, meant that when a threat bypassed their indemnity, the perimeter fence, their entire fortress was exposed. One failure bankrupted the enterprise. This is the difference between legal box ticking and strategic risk architecture. And today, we are going to give you the blueprint. Welcome to the Deal Fortress Framework. This isn't another checklist. It's a 3-layer system for thinking about your contracts. It transforms them from static documents into a powerful defense system built around your most valuable asset, your future cash flow. Let's architect this layer by layer. Layer 1, the perimeter, your first line of defense. Its job is to push external threats away from your business. Its primary weapons are indemnity and force majeure. Let's start with indemnity. Simply put, it's about making someone else pay for their negligence. Imagine you're a Delhi-based D2C brand. You hire a marketing agency. They create a campaign using an unlicensed image, and you get sued by a stock photo giant for 25 lakh rupees in copyright infringement. A weak, checklist-level indemnity clause leads to a year-long court battle. But a fortress-level clause is a razor-sharp shield. It specifically covers IP infringement and contractually forces the agency to immediately take over the defense, pay all legal fees, and handle the settlement. The threat is deflected at the perimeter. Your business doesn't even feel the impact. Next, force majeure. This neutralizes risks you cannot control. A Surat-based textile manufacturer has a massive contract with a European retailer. A sudden government lockdown shuts their factory. A weak clause just says, "acts of God." The retailer argues a lockdown isn't a divine act and sues for millions. A fortress clause is specific. It explicitly lists these modern risks. The manufacturer has the clear right to suspend their obligations without penalty. The macro risk is neutralized. But what if a threat breaches the perimeter? That brings us to the most critical layer. Layer 2, the Citadel, your core asset protection. This layer contains the damage. Its single most important weapon is the Limitation of Liability, or LOL. This is the financial firewall of your contract. A cloud services provider in Hyderabad hosts a database for a fintech app. A server goes down. The fintech client loses 50 lakh rupees in business. With a weak or non-existent LOL clause, the provider is now facing a lawsuit that could wipe them out. But a fortress contract has a ruthless LOL. It does two things. First, it caps your total liability to a fixed, manageable amount, like the total fees paid in the last 6 months. So the 50 lakh rupee catastrophe becomes a 3 lakh rupee operational cost. Second, it explicitly excludes liability for abstract damages like lost profits or consequential damages. The damage is contained. The Citadel has protected your core assets. This is the clause you never delegate. Finally, what if the partnership itself becomes the threat? Layer 3, the Sentry exit, your controlled disengagement plan. This is your pre-planned clean escape route. The Termination clause. A manufacturing company in Pune signs a 3-year exclusive deal with a key supplier. A year in, that supplier is acquired by your fiercest competitor. A weak contract only allows termination for a breach. You are now legally trapped, forced to feed strategic data to your rival. It's a strategic checkmate, but a fortress contract includes a change of control provision. This gives you the unilateral right to terminate the agreement if the other party is acquired. This is your Sentry exit. You pull the trigger, end the deal cleanly, and live to fight another day. Perimeter, Citadel, Sentry exit. It's not a list of clauses, it's a system, an architecture, a way of thinking that separates amateur operators from elite founders. Stop checking boxes, start architecting fortresses. Your company's survival depends on it. You now understand the theory of the deal fortress framework, but theory doesn't stop a 50 lakh rupee lawsuit. Action does. How do you apply this thinking to the dense 50-page master services agreement that just landed in your inbox? How do you spot the cracks in the fortress you've already built? That's why I engineered the contractual red flag scorecard. It's not more theory, it's a diagnostic tool, a 15-minute stress test that translates complex legalese into a simple, actionable risk score, specifically built around the Fortress framework. It helps you move from passively watching this video to actively protecting your business. Right now. For less than the cost of a single billable hour with a junior lawyer, you can gain the strategic clarity that top founders use to de-risk their most critical deals. Stop wondering if your contract is a shield or a liability. Know for sure. Click the link in the description below. Get the contractual red flag scorecard and start turning your contracts into a competitive advantage today.